Good afternoon, everybody. It is 2 o'clock and it is time for us to start our COPEC Daily Financial Wellness Webcast. We really appreciate everybody joining us today. Today we got a really good program. We're going to be talking to Russ Golowin about basic wills and really kind of digging into the basics that I think everybody should really know about. And so we're excited about having that discussion today. Also, as you can see, we've got our disclosure up there. This is really about COPEC, our speakers, affiliated companies. For example, myself hosting these programs, I'm also on the board, I'm president, and so therefore I'm an affiliated company, and we have some information in there about our company as well, so that we have that all out there for you to see. You can obviously see this as well on the copeceducation.org website, down at the bottom, disclosure, and you can see it there. Now we're going to kind of get to our topic of the day, and Russ will be joining us here, and we're going to really break into the concept of basic wills. And so Russ, thank you again for joining us. Russ is a regular attendee and participant with COPEC and also on the board, so appreciate your joining us today. And what are we going to really get into?
Well, today, Jay, I just want to talk about basic wills, what they are, what they can do, and then also what can happen if you don't have one or don't have one that's appropriately set up. So just basically a general overview of a will and how they work and what they do.
Well, that's great. Why don't we go ahead and go right to the core starting point. What's the purpose of a will? What are we even dealing with here?
Right. Well, I think most people know a little bit about a will. They've either, maybe they have one. If they haven't, they know of a parent or other loved one that maybe had a will, or who knows, maybe they just know them from books or movies, dramatic will readings and things like that. Really, yeah. I mean, really though, a will, number one, is your set of legal instructions of who gets what, how much they get, when they get it. That's number one. Number two, it's, again, your legal instruction of who you want to be in charge of the probate process. And we'll talk about probate in a minute. And then sometimes if folks have minor children, a will is a good spot where you can name guardians for those children so that if you die, you'll have somebody that you've chosen to raise those children until they're 18. Those are probably the three main reasons, most common reasons that folks should think about definitely creating a will.
Well, that's really interesting. And you really take this and break it down with different options that people have as far as leaving property and money to their children or their family. Could you break that down a little bit for us?
Yeah, that's a good question. You have many, many options, and sometimes all the options can just make someone feel overwhelmed. So what I try to do as an attorney is help by talking with people, kind of guide them so they can choose from maybe a few options that seem to work out for them, as opposed to giving them every option under the sun. But really, if you think about it, there's a few things, maybe four things to think about. Number one, do you want to leave any specific things to a particular person? That could be a diamond ring, it could be, a piece of property that's really valuable, or it could be things that really have no value at all. They're just sentimentally powerful. I could leave a particular hat to my brother, right? It could be anything you want. So specific things are one thing that you can designate in your will. You could also say, I want this specific person to get $1,000 or $5,000. That's a specific distribution of money. And so you could have these things going off the top, specific amounts of money going off the top, and then you're left with the remainder, whatever's left after that. And so you might say, well, I want everything else to go equally, and I want my children to receive it, and they're just going to get a check when I die. That's called an outright distribution. Or you could say, I want this person to receive money, but it should be held in trust until, they're 25 years old if they're a younger person. Or if you know that beneficiary has a disability or special needs, you might say, I want this money to go to them, but be held in a special needs trust that makes sure they're not made ineligible for government benefits because they receive that money. Of course, that doesn't apply to everyone or everyone's family, but that's a very powerful tool. And I do want people to be aware that that's an option. So just to recap there real quick, as far as who gets what and how much and when they get it, you can have specific distributions of things or money, and then you have to decide where the rest goes, either outright distribution or held in trust until some later date.
Back in your previous comment, kind of the purpose of the will, I'm kind of intrigued with what you were saying as far as, minor children and things like that. Can you dig deeper into that a little bit? Because I don't think a lot of people understand really how human beings are handled who are minors, right?
Right.
We talk about, and you're right. I mean, you think of like those movies with the reading of the will and cousin Janie got left out and she's upset or whatever happens, right? But rarely do you see, somebody who, and it's always, by the way, it's always somebody who is great grandfather Jones or grandma, Jones, who is 94 years old, and they had this great last couple years. I think of things even like the Clint Eastwood movie, and he leaves the what is it?
Gran Torino.
Gran Torino, right? And so they're like going, the granddaughter is all upset because, what do you mean I don't get the car? It goes to this other person who became his friend in the last few years, and it's very dramatic. Well, let's change it, and let's say that it's a 35-year-old parents who have 3 young children, all under the age of 10, right? What's the dynamic there with the minor children? Because I think a lot of people are confused about that. They get the car, I give the car to Joe,
right?
And everything else is. But what about those children?
Well, yeah, the basic concept is if I die, or if both children's parents are still living, if both of us die, who will raise those children until they're 18? And unfortunately, if you die without a will or without nominating a guardian in a legal document, you've just lost your ability to suggest to the court who you want to be that guardian. So the court will do their best to try to pick among the people who are willing to do it. But one thing I've always thought about there is that in certain circumstances, the court might be unintentionally set up to pick the wrong person. And what I mean by that, this is a fake example, by the way, but let's say my brother is really wealthy and has plenty of room in the house and could afford everything that my children could possibly want. He might look better on paper than my sister, who might be a brand new teacher and not have a lot of money in the bank, and just looks like she might not be able to care as well for my kids. And so maybe the court would pick my brother, but the court doesn't have any way of knowing that I didn't share his beliefs on, religion, politics, education, or a whole host of other things. Maybe I just didn't like him very much, right? Court wouldn't know that. They might accidentally pick the wrong person. So one reason to make a will is to nominate a permanent guardian for minor children if both parents pass away. And by the way, one thing that trips people up is they say, well, I don't need a will because I don't have that much money, and there's not any money to provide to the guardian anyway to help them raise the kids, so I have to pick my wealthier brother. Well, that's not true. You can definitely work with a financial advisor, talk about life insurance. You know, there are certain kinds that are pretty inexpensive. You can get a lot of coverage. If I die, even if I don't have any real savings, now there's life insurance that can be used to pay for my children when I'm gone.
Yeah, and a lot of people who have minor children, they may not think they have a lot, but the problem is if they died that young, chances are they died of a wrongful death, a car accident,
Yeah.
some of those things, especially if it's both spouses, where there may be a settlement that comes in, or, a lot of times if you work at a company or the state where you have these group benefits, right, you may have some already built-in life insurance there. So even though you may think you don't have a lot of money, your death actually created either through wrongful or something like that, where you never planned on this.
Right.
But sometimes these things start coming in that are different than if you were 78 years old and you passed away in an expected situation. Obviously, you wouldn't have minor children then.
Yeah, I mean, that's a really great point. That's absolutely true, Jay. So yeah, I mean, it's one of those things. If you do have minor children, you definitely want a will for those two reasons. Nominate a guardian, and there's probably, even if you don't have any savings or any life insurance, like you said, Jay, there could be money coming in through some sort of tort or lawsuit of some kind.
Right.
Yeah.
Hey, this brings up an interesting point that I think is well, I have two thoughts going through my mind, and because I'm the host, I get to go ahead and share them. No, I'm just joking. But a couple weeks ago, we did a discussion about a pet trust, right? And I think for our listeners, go back to the library, listen to some of these things, because it's really interesting how, you could bring all these concepts together. But if you were to have a will and you are to leave funds to, you leave your children, and you want them to go to your teacher sister, as you explained, you can put in the will, and I'm stepping on the toes of your expertise, Russ, but you can put in the will something to create a trust to provide that income to your sister to care for your kids, right? And,
Exactly.
and maybe money left over for the kids when they become of age. Can you talk about that a little bit?
Yeah, actually, now that you mention that, I think that's really critical that we discuss this one point, which is many people are predisposed of thinking, well, if I die and I have children, I want to leave everything to my sister and then she'll take care of my kids with that money. To me, that's most likely a very big mistake, because if I leave the money to my sister and she dies, well, that money is going elsewhere. If she's incapacitated, we might not be able to access that money to use it for my kids. If she's going through bankruptcy, lawsuit, divorce, all those sorts of things, it could be diverted accidentally away from my children. So in almost all cases, I think it's fair to say that you want to create a trust either in your will, or you might create a revocable trust during your life that says the money that I leave behind goes to my beneficiaries, maybe my children in this example, and someone else, it might be my sister, is going to be the trustee. The trustee has the legal duty to only use that money in my kid's best interest, not hers. So if she takes money out for herself, she can be sued and she could go to jail. And then I'll leave instructions in there, such as, I want my sister to pay the trust money for my kids' health or education, like college, basic support, like helping her get new tires on her car. All that sort of stuff is covered. And then you might say, oh, and then maybe my kids, they'll get half when they turn 25 so that they don't blow it all immediately when they're 18. And then maybe they get the remainder when they're 30 or some other age that I'm comfortable with. So there's a break in time between getting half and maybe being irresponsible with that money. And then they grow up a little bit over the next 5 years when they get the remainder. Those are some concepts to think about.
That's an interesting point too, because back when you were talking about selecting different people as your guardian, maybe your brother is a great option, right? He's, all of these things. But what the court doesn't know is that they're having a rough marriage, right? Maybe you kind of have an idea and you don't want to risk it. You don't have a trust set up and you're assuming whoever gets the money, well, you know what? Maybe I can get it to him even though he has a rough marriage, but I need to get this trust in place. I mean, you can do a number of things to help protect not only your kids to be in the right place, but to protect that money. And I think that's really a powerful concept for people to truly understand. Once it's out of your hands, if you don't legally set this up in a protected way and get it in the right people's hands, and even if you think it's in the right hands, there's still things that can happen. Think through this stuff, because that's how I never expected it to happen to me. But when it did, do you want your kids to pay the price, either being in the wrong home or the money was lost due to divorce, or maybe they got sued or whatever it is. There's lots of things that could be, and it doesn't take a whole lot to get it set up.
That's right. Yeah, I will mention one thing, and this is sort of unfortunate, but for those that do set up trusts for younger people, it doesn't have to be children, right? It could be nieces and nephews or just people that you care about. If you do that in a will, unfortunately, because all wills have to go through probate, that trust is going to be set up in the probate court, which then means if that money is being held in trust until that young person is 30 and they're only 20 when it started, you're going to be filing court paperwork every year for 10 years. So over time, doing this in a will might end up being more expensive than if you just created a revocable trust during your life. But either way, yes, you can create these trusts and these instructions of when folks will get their money. And it's equally effective. It's just sometimes, or it will be more paperwork and time and cost over the long run if you do it through a will, which goes through probate. That's a little bit complicated to understand, I realize, but I thought I'd just throw that out there for discussion.
Yeah, and you bring up another really good point. Not only are probates public, right?
Right.
They're public, and so therefore anybody can see what went through your probate, what you own, all of those things.
Right.
And so there's the issue of what is public, what is private. So maybe that's a discussion at some point. But also a will. Can you comment a little bit about the idea that a will, it isn't locked in stone. It's like evidence. And the judge or people can fight against that evidence, right? I think I remember, I'm going to screw up the details, but I think it was Ted Williams, he had a will, but then his son had a separate will that was written on a napkin or something like that. And he in this will, he wants his head frozen or something like that. Well, it's just evidence. And then all of a sudden now you got different people going, no, the will's not valid, or he wasn't of sound mind, or he didn't know this. And so the judge has to now determine. So in the majority of people's cases, it's pretty solid. Unless you get somebody who was kept out of the will, and then they come back and they go, no, I cared for them the last 4 years of their life, and he would never do that, right? I mean, it's evidence. Am I understanding that right?
Yeah, I mean, I guess one thing I can say is there are very specific rules of who is entitled to notice that a will is being probated. And by being probated, I mean they're giving the original will to the court, and the court then is going to hold a period of time where everybody can contest the will. And so what that means is when I'm trying to get appointed as executor for my brother's estate, I'm going to give his will to the court. I'm going to give him $250 for court costs. The court's going to take that original will And then unless somebody contests it in the next, 60 days, that will be declared valid. But before they will declare it valid, I need to give notice to everybody that's named in the will and everybody who would be entitled to receive something if I died without a will. So that sometimes brings up the point of, if I want to disinherit people, I may want to create a trust instead, because if I do everything correctly with the trust, I'm going to totally stay out of probate, which means I don't have to file a will in most cases, which also means I don't have to notify these people that aren't getting anything. So, that's kind of a whole topic on itself. But what I will say is, some people are very upset when they find out that their sister that they haven't talked to in 30 years, they must notify them that mom died, because if mom died without a will, that sister would also receive some money. Does that make sense, Jay?
Mm-hmm.
So if you're in a situation like that, you may want to consider trying to stay out of probate with a trust. But that's a little bit of an exempt.
Yeah, and I think that's the general understanding that we want most people to understand, is that there are circumstances where going through probate may be better, and I think that might be a discussion for another day. But for most people, there are some things that already miss probate, like life insurance that has a beneficiary, your IRA, joint with right of survivorship, certain titling, they already miss probate. Right. But for most people, the goal is to have most of your assets and your life avoid probate, either through financial costs, complexity for your heirs, challenges, right? A number of those things, right? I mean, I don't want to say that's required in all cases, and I think you want to check those unique things. But for most people, we want to avoid probate. Just it's not needed.
Right. And one thing, I think I sort of mentioned it a minute ago, but just to be totally clear, a will doesn't do anything until you die and someone opens up the probate estate in the court. So there's a misconception of, hey, I got my will taken care of, so I'm avoiding probate. That's not true. That's the opposite, because a will must go through court. And we're not trying to say that that's a disaster in all cases. We're not saying that at all. But if or when you create a will, then you can try to look at, hey, I want my daughter to get everything when I die. So maybe I can get a transfer on death car title at the BMV, so that instead of having to take that car through probate to get to my daughter, I can just have it go directly to her when my daughter gives the BMV a death certificate and pays $20. So there are definitely things like that you can do, but it should always start by getting your will in place and then trying to take steps to avoid having to use it. It sounds kind of funny, but you always want to make sure you have the basics taken care of in case something's forgotten about, or in case one of those beneficiaries you name isn't living when you die.
Yeah, and for those that are listening, think of it this way. I've got two daughters, and I want to give them some money for a trip. Okay, it doesn't matter what it's for, and I want to give them each, $1,000 for their trip. So I write a check, I give them that money for their trip, and they go on their trip. I didn't tell anybody about the trip, and I didn't get permission about the trip. That's kind of what not going through probate does for you, right? You can make a beneficiary, hey, daughter, when I die, you're going to get this money, and when I die, it's going to go to you, and you get it. Mm-hmm. Whereas with probate, and I'm oversimplifying this, I'm sure, but with probate, it's more like saying, back to that trip idea, hey, daughter, I want you to be able to have a trip. okay, judge, is it okay that this money gets put to my daughter? So everybody that's listening, they hear that I gave that money to my daughter to go on a trip. And oh, by the way, everybody listening, judge, can you please make a ruling that my decision to give my daughter that money, confirming, is it am I kind of playing this right? People think, wow, it's going through probate, it's a will. Well, it's public. Hey, daughter, everybody, my daughter, I'm giving her $1,000. And two is, hey, judge, can you please confirm that that can happen the way I'm saying right now, as opposed to keeping it out of probate. It's quiet. And I don't need any judge to look at anything because it's my money and I can do what I want with it.
I think that's a pretty good example. Yeah. I mean, again, like you said, it's not exactly like that, but
that's a caveat. That's the Jay Linder a horrible metaphor, maybe. I don't know, but just remember that you can keep it private and you can keep it public and you can make it as whatever you want, as long as obviously within all the legal rules. But people just think it just happens, and it doesn't. Which, let's wrap that up to, why is it important for everyone to have a will? Everybody should at least have one. It might, even if you do a good job protecting or whatever it might be. We've got, it's 2:30 here. Let's wrap it up with that question here. But can you kind of send us off with that one?
Yeah, I mean, just real briefly, number one, again, you can't be certain that all the beneficiaries you name on your different accounts will be living when you die. So you want that will to be in there to lock in who gets what and how much. Number two, your executor of the will or your executor of your estate, you have to name them in the will or the court will decide. And so if you don't have a will, well, then the court is going to pick an Ohio resident. It can't be someone that lives out of Ohio to be in charge. So you would lose the ability to do that if you don't have a will. And then number three, you just want to make sure that, again, you have your legal instructions in place of where everything goes, who's in charge, and maybe if you have minor kids, that you've named a guardian for them. Those are three big reasons why everyone should have a will.
Well, I think that's a pretty good review. I do think there's a lot of confusions to wills, especially for people that are younger. There are so many laws and so many rules and so many advantages to going different ways versus others. And I would highly recommend that everybody has to have a will. I mean, they don't have to. Everybody should have a will. And if you don't have your own will, the state has one for you as a default.
That's right.
But get a will, either do it on your own, talk to an attorney, get some advice, but you really need to have that in place. It's going to make your heirs, your beneficiaries, so much happier that at least is in place and gives some ideas to what you want. Thanks everybody for listening in. Russ, thank you so much as always for sharing your expertise with everybody. We'll be back next week. I'm not sure what's on the docket, but everybody make sure you look at the calendars and have an idea as to what the topics are so that we can continue to share this great expertise with you. So everyone have a wonderful weekend. We'll see you Monday. Russ, thank you so much, and we'll talk to you soon.
Thank you.
Thank you, everybody.